Hi, I'm Ashleen Sluters, Managing Barrister at Edwards Law Employment Law Specialists. It's critical to get disciplinary processes right. If not, even if you've got good grounds for disciplinary action, you could risk a personal grievance claim for unjustified disadvantage or unjustified dismissal. The blog from my colleague Kate sets out the potential remedies available for unjustified dismissal. To avoid this, I'm going to take you through 8 key steps to ensure you have a procedurally fair disciplinary process. Step 1. An act of misconduct arises. Before taking any steps to discipline the employee, even if the act is overt, it's important to make sure that you comply with a fair procedure. Step 2. Decide who will be responsible for the disciplinary process and the decision maker. First, consider whether this person has any conflict of interest. If the issue is very serious or sensitive, it may be advisable to have an independent party for the investigation. Step 3. Check the relevant clauses in the employment agreement and any relevant policies you may need to suspend, in which case, please see the vlog by Rachel. Here you'll be looking for disciplinary procedures or terms in the employment agreement or code of conduct relating to the alleged conduct. Step 4. The employee must be advised of the allegations against him or her in writing and asked to attend a formal disciplinary meeting. They should be given at least a day's notice, and sometimes more time will be required. The employee should be provided with all of the evidence being relied on, be notified that they can bring a support person or representative to the meeting, and advised of the possible disciplinary outcome if proven. If the evidence relied on is what another employee has said, a statement from that employee will be needed. Step 4 is really key to getting the process right, and will set up the process going forward. Step 5. At the disciplinary meeting, confirm that no decisions have yet been made and listen to the employee's responses with an open mind. Step 6. The meeting should then be adjourned to consider the responses and make any follow-up investigations that may be required. It may be appropriate to deliver the outcome after a short break. For example, where there is nothing to investigate, where you're only considering a warning, or where the employee has accepted the allegations. Step 7. If a further meeting is required, in that meeting confirm that you've considered the employee's responses and advise the employee of your preliminary decision regarding the disciplinary action. Then give the employee an opportunity to comment on the proposed disciplinary action before confirming your decision verbally. You should then let the employee know that a letter confirming your decision will follow. Step 8. The written warning or letter of dismissal should be drafted and issued after the final meeting. If issuing a written warning, specify how long it will remain on the employee's file, which is usually about 6 to 12 months. Each disciplinary process will be different. Having templates you can go to is really helpful. It's always best to seek advice from the outset so that you can commence and continue a procedurally fair and substantively justified disciplinary process. If you have a disciplinary concern arise and need prompt and professional advice, please don't hesitate to contact us.